Welcome to 7728 Law, Global Law, where today's topic will be about resolving disputes in international law, Part 1. Today, I'll be answering the seminar questions 2 and 8. I will first address the International Court of Justice and the following questions. The International Court of Justice, ICJ, known as the World Court, was founded in 1946 and is the main court of the United Nations, which replaced the Permanent Court of Justice, PCIJ. This makes it the highest appellate court in the world. The ICJ consists of 15 judges, with at most 2 from each state. These judges must exemplify qualities and characteristics found in Article 2 of the ICJ statute to be considered candidates, who are then nominated by the states. Those with majority votes within both the General Assembly and the Security Council are elected. These positions are held for 9 years, with possible re-election, though the current process has been criticized for the political drive. Over the years, the ICJ has given over 100 judgments and has accepted 25 requests for advisory opinions. In 2011, there was a rise in dockets in the ICJ registry, which displays confidence in the system, though this is predominantly from developing states. The jurisdiction of the ICJ can be found in Article 92 and 93, subsection 1, which states the ICJ is the principal judicial organ of the UN, and that all members of the UN must adhere to the ICJ statute. This means only recognized members of the UN or states who uphold the ICJ's jurisdiction may dispute. The jurisdiction of the court is further clarified in Article 36, subsection 1, which pertain to all cases specifically provided for in the Charter of UN or in treaties and conventions in force. Article 6, subsection 5 and 37 also states automatic transfer of such jurisdiction from the PCIJ to the ICJ. As per Article 36, subsection 2, cases must be considered legal disputes to be brought forward to the ICJ. If the ICJ determines it has jurisdictions, it follows the competence de la competence principle, meaning the court will decide on its own jurisdiction as per Article 36, subsection 6. Although there are objections against this, where local remedies were not exhausted beforehand, the matter may be solely in domestic realm, or the issue is predominantly political. Regardless of this, the court will exercise its rights as long as there is a legal dispute. Article 36, subsection 1 requires state parties to refer their case for determination to the ICJ, which can be achieved in various methods. Firstly, the special agreements or compromise allow states to request the court to advise on specific disputes, including relevant principles of law governing the conflict. This provides clarity and certainty for these disputes. It is generally used for territorial disputes such as the Mini-Creers and Equios case. Secondly, the forum prorogatum enables states to make a unilateral applications where under certain circumstances the court determines the state's subsequent genuine consent to their jurisdiction. This provides a state a chance to convince the ICJ to adopt interim measures of protection. However, this method of use has declined as Rule 38 subsection 5 of Rules of Court requires explicit consent of the respondent state before the application to the court is considered effective. Finally, the optional clause in Article 36 subsection 2 provides states opportunities to recognize the jurisdiction of the ICJ. Legal disputes concerning the interpretation of treaties, any questions pertaining to international law, evidence of facts that if agreed upon could breach international obligations, and nature or extent of reparation for breach of international obligations can be brought to the ICJ. States may terminate their declaration of the ICJ jurisdiction by simple notification, similar to the 1957 rights of passage without requirement of a notice period. However, this is unlike the Nicaragua case, where 6 months' notice was asserted by the US, who removed their declaration but did not adhere to the notice period. The ICJ has provisional measure powers outlined in Article 41 that allows them to preserve the respective rights of either party. This allows the court to act expeditiously to prevent irreparable injury to dispute which is binding to relevant states. States typically seek declaration judgments claiming that the state at fault has breached international law. However, as indicated in Article 59, the court has no binding except between parties in dispute for that case. Article 94 requires all members of the UN to comply with ICJ decisions. However, the Security Council refrains from actioning the ICJ decisions due to political reasons. Consequently, states may seek an alternative option in advisory opinions from the ICJ for guidance, as per Article 65, subsection 1. This gives the court power to provide opinions regarding any legal questions at the request of any authorized body or in accordance with Charter of UN. This provides guidance on legal principles concerning particular domains of law, though this is non-binding law. This concludes an overview of International Court of Justice. Next, I'll be addressing international arbitration and exploring the differences from judicial dispute resolution. International arbitration is a consensual binding method of dispute resolution. It is a confidential process which protects commercial practices, trade secrets, industrial processes, and knowledge of dispute. Arbitration awards are enforceable in countries that have agreed to the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards, 1958, or known as the New York Convention, enforced by 154 countries. This is unlike the courts, where the cases must be made available to the public, and their enforcement is dependent on the reciprocal enforcement agreements in place. Arbitration is usually conducted in a neutral environment to all parties. It allows the parties to determine how and where the procedure will be conducted, including the location specific to which country, city, and buildings. Parties may also choose to have the arbitrator's observation over the dispute. The selection allows the parties to discern and choose those that are more skilled and knowledgeable in that dispute. However, unlike judges who are free of charge, the arbitrators must be paid by the parties. Arbitration parties may agree to restrict the appeal for faster conclusions of the proceedings than that of the court, though many jurisdictions do not allow this. The award is final and binding, and cannot be set aside by grounds of error or facts, unless in exceptional circumstances. Arbitration may fail for the following reasons. If the agreement is not under valid law, there has been a lack of proper notice, the award falls outside of the terms submitted arbitration, the arbitration procedure misaligns with the agreement, the award is not yet binding on all parties, or is suspended by the competent authority. When a dispute arises under the contract, substantive law must be utilized. This is usually stated in the arbitration clauses within the main contract, which are severable, though in most cases arbitration agreement is governed by the same laws of the main contract. In cases where the arbitration of the agreement is entered after, it may not follow the laws of the main contract. Procedural rules of arbitration must be chosen carefully. The first option is the institutional rules, which are administered by an arbitration institution. This process is recognized and is reasonably predictable. The institution oversees the conduct of the arbitration process, acting as a form of quality control, appointing arbitrators with appropriate record and experience. It is more costly, though this may lead to fewer procedural difficulties and thus reducing time and expenses for the future. The second approach is the ad hoc approach. This process is not administered by the arbitration institutions, but rather parties are able to choose their rules and arbitrators. It is more cost-effective, faster, and flexible, making it more popular. There are many rules to choose from with this process. One of the most common rules is provided by the United Nations Commissions on International Trade and Law. The Commission provides patterns and templates for domestic law governments to follow. Alternatively, the International Bar Association provides rules on taking evidence in international commercial arbitration. The powers of the court are determined by procedural law of arbitration, the procedural rules, if chosen, and the arbitration agreement. This affects the right to appeal and enforce the awards. Arbitration clauses must ensure the following are considered. First, the location of the assets, ensuring that the assets can be obtained. Second, protection. If a state is involved in the arbitration, is there an investment treaty protection? Thirdly, the type of arbitration, as discussed, ad hoc or institutional. And fourth, choice of seat, the extent of which the courts will enforce the award. The following basic elements must also be included in the clauses. Referral of existing or future dispute to arbitration, incorporation of rules governing the arbitration, reference to the place of arbitration, place of hearing, choice of language, number of arbitrators, and reference to substantive law of agreement or contract. Thus, these issues are crucial when dealing in international arbitration. This concludes question 4 of Week 8 seminar.